It's been days. I've given quality time to my son. Given at night 10, 11, 12, I'm on my phone. I'm glued to my phone. So,
It can be a stressful job. Yeah.
it's a stressful job. There are other brokers and they're like, get off that deal.
Always someone in
I'll
his
get you
ear.
3% more.
Yeah.
Yeah, exactly. So when it comes to the end of a contract and there's no extension clause, ultimately the seller can walk away if they choose to, if you go past the date, because there'll be nothing in there to legally keep them in there. You'd probably have to go into some kind of conversation with.
Yeah, 100%. I think people skim over it and you don't realise that normally you have to pay the agency fee still, or pay a 10% penalty and all of those details. They need to go into it and read it through with a fine-tuned code.
People actually don't know what will be the consequences. Hi and welcome to Real Talks with Mansoor. Today I have lovely people comment. Co-founders of Chartered Conveyancing, Lauren and Andy. So these are the people who take the deal from signing an MOU to the trustee office. Easy and short. Now I would like to ask you guys, if I ask you what is conveyancing. I'm a broker, I know what conveyancing is. But start with you guys. I know you guys, if conveyancing as a service, what is conveyancing for the audience to understand?
Yeah. So in short, as you mentioned, it's getting the deal from your contract up until your final successful transfer. The longer version of that is it's all the bells and whistles in between. It's dealing with the banks and their timelines. It's dealing with developers. It's dealing with old utility bills that might come up. It's dealing with visas that might need to be cancelled. Anything attached to that property to get it through successfully, so that it's moved over into the new buyer's name with no liabilities, no problems, and completely clean slate to start from there.
As kind of streamlined as Dubai is, basically taking a transfer from contract all the way to successful sale involves a lot of running around the country. There's banks involved. It might mean meeting with the banks, helping set valuation appointments, going to settlements, following up with developers, maybe even with other institutions like the Rental Dispute Committee or the DRD directly, just in case there's IT issues on the title deed, or maybe there's been a block placed on the title deed because of mispayment of service fees and little things like that. So basically, what conveyancing is we will do all those follow-ups and do all that communication to smooth out the process for everybody involved, so that it kind of reaches the land department and successfully transfers as quickly and smoothly as possible.
But coming to that, when I as a broker joined Dubai real estate, I wasn't aware of this term conveyancing. I was taught by my company to do it by myself. And then later, in stage, we introduced conveyancing. But when I was introduced to this term conveyancing, I was against it. I was like, I can do it. And why will my buyer or seller pay like 4,200, 4,200, 8,400? This is like extra fees.
Yeah.
But after having certain experiences, I felt, oh my God, you guys are the deal savers. You guys are the deal savers, because maybe I've had easy transactions until then. After that, I face the complicated ones. So I want to know, what advantages do you bring?
Yeah, I think, as you say, I think a lot of agents are taught that way. I think a lot of companies still have that mentality, yet you don't need a conveyancer. And in short, you don't have to have one. Being completely honest, you don't. There are transactions that are smooth, that will follow the process step by step and get to transfer without any hassle. But in reality, I would say that's maybe 5 to 10% of the amount of deals. The rest will have hiccups on them along the way. They'll have small problems or big problems and bumps that we have to overcome. I think from an agent perspective, the biggest thing we can say here is time, and your time is money, right? For you, if you can sign your contract, hand it over to us, and then we call you at the end to say, come and collect your commission check. You've saved hours per week of running around, as we just mentioned, all those different places, being up and down on Shakeside Road, following up the calls that we have to make. All of that time, you could be calling your next client, you could be viewing, you could be selling, however many properties. So the biggest advantage for agents is your time. There's also, we're experienced now. I've been here for 15 years, Andy's 16 years. We know a lot of people. We know where to go. We know who to see. So something that may take you as an agent 3 or 4 days to find where to go. We've already done that before, and we can go straight there. So there's connections, there's networking, and yeah, as Andy mentioned, to try and streamline that and make it as smooth as possible, because we're doing these transactions every day. Generally speaking, we can get there quicker, and that's a better result for you. Like I say, for your time, for new deals, for getting this deal through to get your commission quicker, and for the clients to be happy.
Coming from what you have said, it feels like it's more of easy job to the brokers and the agents. But what have you got for the buyers and the sellers? Because they're the ones paying you for this.
That's because we're the experts. Ultimately, it's an administrative role. And yes, technically, I suppose you could send anyone out to do it, but it doesn't mean they know what they're doing, and it doesn't mean they're being guided correctly. If something's going wrong, people might say, this is how you fix the situation, or this is how you get past this particular bump in the road. But that could be a miscommunication, or the advice could be wrong. So this is where we bring our expertise, our experience. It's like an insurance policy, basically. We hold the client's hands and we guide them through it. We keep the contract secure, and we know how to address the situations as they come up. It might mean we can just fix it without knowing. It might mean we need to inform them to give some assistance or guide them on what to do. And it might even mean just having a quick renegotiation with the clients, because maybe there's an issue that we need a little bit more time to solve than we didn't solve. But because we know how to communicate that properly, usually people kind of listen and follow suit, and that helps us get the deal through.
I think just to add to that as well, the reason you're saying the client's paying rather than the agent, we are there to protect the client ultimately. Yes, it does help the agent. Obviously, as I mentioned, there's huge advantages to the agent, but actually it's to make sure that deal goes through completely, as I say, completely free of any charges, free of any problems, any unexpected documents or bills or anything to come up after. Our job is to make sure those are all done, and everything, like I say, all the boxes are ticked before we get to transfer, and that ultimately protects the client. So we are an independent party. Yes, of course, we help the agent and we want the deal to go across the line. We're there to protect the client more than anyone. They're the two parties in that transaction, and we're there to make sure that deal goes through as well and as correctly as it should.
Okay. Coming from that, I want to know, as a broker, I have brokered a deal. Is it my responsibility to get a NOC for the seller? He is owning the property, he is a homeowner. My job is to broker a deal. So is it my responsibility to get the documents sorted for the seller, for the buyer, or it's not my responsibility? It's like, I brokered a deal, you provide me these documents, and I take you to the trustee office. That's what I can do. But I don't think they can do it, or they know the process, and that's when you come in. I think
Exactly, and that's I think that you mentioned that the lines are blurred here a little bit, because some agents think it's their responsibility, some don't, some clients do, and we just bring that all together and say, no, that is our responsibility. We know how to do it. We're going to get it for you, and this is what we do. And
exactly. So that's the elephant in the room, actually. Brokers and agents think it's their job to get the NOC for the seller, to get the clearance from the Deva, to get the clearance, all the documents, mortgage release, and everything. Whereas I believe that's not a broker's job. If I have sold your property, it's you who provide me with the NOC, with all the documents. I think we put that in contract F as well.
I mean, brokers don't get trained to do it, do they? If you go and speak to brokerages, I doubt there's a section in the training, in the sales training, that this is the conveyancing you're going to have to do for each particular developer or each particular bank. They just sort of get pressured into it because there's commission on the line. It doesn't mean they know what they're doing. They probably just go and try and figure it out and hope they figure it out well. And it just comes back to expertise again and knowing someone to do it right, because you can't be intimate with all the policies and procedures of every single developer, of the deal, of all the institutions involved. So yeah, it is a blurred line. I personally wouldn't expect brokers to do it. They've not been trained to do it. That's not their expertise.
Just to understand this better, the brokers, the real estate agencies, other than the top ones who are doing this from before, were doing it wrong this entire time, because this is not their job. It's not broker's job. Because if I have faced this difficulty when I broker a deal and I am doing the conveyancing, getting the documents, maybe I have to go twice and thrice to the developer office to get the NOC and get them to respond me, whereas you can do it on a call because you have that network.
Yeah. And even if you do have to, because it's quite common in our job to have to go down and sometimes just be present for like 3, 4, 5, 6 hours in one office to get something moving. But that's what we're paid to do. So we're happy to do it. But that's 3, 4, 5, 6 hours of your broker's time doing viewings, call outs, whatever they might need to do.
And also, and clients' time as well. Often, if the agent doesn't want, there are agents who don't want to do it. They send their seller down there to the developer's office. That's 3, 4 hours out of their time sat there, when again, they could pay us direct.
But most of small agencies, I would say new agencies, small agencies with a minimal team, they don't do this. They give conveyancing from their side and they don't train their agents. I've worked on A to A and I've had argument with other agents where their buyer does not want to pay for the conveyancing and my seller, I've convinced him. So according to me, in secondary, we have to convince the client twice. One is first select the property for them, show them the property, get an offer, convince the seller to sell the property at this price. That's part one, and then
That's
comes
the
the
broker's
part
job
two.
there, isn't it? Yeah.
And then comes the part two where we have to say, okay, so this is the total cost, and we slip in sales progression. And
Can I ask a question about why is it slipped in at the end? For me, it should be part of, these are your costs. You're going to buy a property. You're going to need to pay the land department. You're going to need to pay an agent. You're going to need to pay a conveyancer because it's part of the, for your protection, it's part of the transaction. You're going to need to pay a trustee fee. It should be an upfront cost. If it's something that you practice.
once you select a property, that's when I give you this, like, okay, you've selected a property, your budget is 1.5, you've selected a property of 2 million or maybe 1.8 million. Now I will send you the breakup. So you have finalized, put up an offer, the offer is accepted. Now I send you a message or email saying that this is your fees and you have to pay sales progression or maybe conveyancing 4,200 or maybe 8,400, depends on, what the broker is splitting the conveyancing in buyer and seller, or only the buyer has to pay. It depends on that, depends on the situation. So basically after that, and then the buyer comes up with, sorry, what is this charge? I know the trustee fee, I know the DLD fee, I know, but what is the sales progression or conveyancing that I have to do? I have to pay for. I've never heard this charge. So a lot of people don't even know that something as conveyancing is there, and I have to explain them. So, I have to explain them, give them a comparison that, yeah, there are other agents, other brokers who are doing it, but they don't give you the kind of service we give.
Yes, I think as well. I mean, in terms of pricing, yeah, there's a range of different prices in-house and independent as well. But for both services, is that peace of mind, as we discussed previously. It's knowing they put that insurance policy there. If something goes wrong, they've got someone standing in their corner to get that across the line with limited hassle or inconvenience to them ultimately. I think as well, just to add to that, I would always try and have these discussions before an offer's put in. I would, you're going to put in an offer for X amount for your property. Have you been told about all the additional fees? That's one of the biggest things I think that we find with contracts that come over to us. And some clients don't even know about a trustee fee that you've mentioned, because it's for them, they've just been told 4% and 2%. You've got 6% fees, that's it. But no, by the time you add on a trustee fee, a mortgage fee, or a loan processing fee, like I say, a mortgage release fee for sellers, there's not hidden costs, but they're not everybody knows about them. So have that discussion early on in your negotiations. You're going to put an offer in. Do you know about all these other fees? And then it's an easier transition, I think.
So it depends from case to case. I won't inform you all these fees or all these charges until you have chosen a property, until you are willing to place an offer and you want to discuss with me, okay, so I'm placing an offer at 1.5 million. What will be the cost? Extra cost. Okay, so what I do is I simplify things. I'm like, see, 4% DLD, 2% agency fee, and overall cost will be 1%, including the trustee fee, sales progression. So I give round off 7%. I'll give you a breakup once we have placed an offer. Does that make sense? Like, it's much easier. So you calculate like 1 million property, okay, you have 7% more cost to come up. Easy for buyers to calculate.
Yeah. Yeah, I'd agree with that. Yeah, like I say, as long as it's just making sure they know up front that they're discussed. The earlier you can have the discussion, the easier it becomes, I think.
The reason for me doing this podcast is for buyers and sellers to know that there is a service known as conveyancing, which makes their work easy, because as a broker, it's not my responsibility to get you a NOC from the developer, to get you a NOC from the building
Yeah.
management.
I would also say as well, it's easier for us, as Andy mentioned before, to preempt problems, to try and, get ahead of any bumps so that we can make that deal go smoothly. Then later on, if you haven't paid for the conveyancing, we're 4 weeks into the contract already, and we've got 1 week left for us to come and save the day, if you like. Yes, we'll come in and we will help, but it's a lot harder to do that process. So again, if you know someone's got it and can like I say, navigate those twists and turns before we get there, yeah.
So just to make it easy, if we can just address the whole process of buying a secondary property, I don't think conveyance is required in off plan and leasing. Leasing, of course, not, but off plan,
Only when it goes into the secondary market. So the initial
Only
purchase from the
resale.
developer, not necessary, but if they then want to sell our payment plan onwards, that's when we would come involved and do
come
the
in.
do the
Okay.
conveyancing again.
So if we can just address me as a broker, I have a seller and a buyer. So I do a contract A, contract B. I merge both the contracts, form a contract F, which is also known as MOU. After that, the case comes to you guys.
Well, if I can just jump in a little bit, actually, I don't know, what we like to do is actually kind of maybe get in a little bit earlier before you finalise the A and B into the Form A, just to advise. We've got lots of contractual experience. If a broker would like just get some advice, maybe they'd kind of see the structure of the deal, but oh, how does this developer operate? How does this bank operate? We can help maybe assist with the special conditions. Say, look, maybe you need to put this one in, bulletproof the contract a little bit more. This one doesn't perfectly apply to the contract, just reword it a little bit. We like to assist as much as we can to make sure the contract is best suited for everyone involved. So we like to advise on those, and we're happy to kind of just offer that to brokers, buyers, sellers.
That's amazing. Because from that, I would like to also address this. A lot of people don't know what they're signing. When they're signing an MOU or a contract F, a lot of people just like have that much trust on the age. I have had those experiences where people don't read. And what I do, I practice this, that I download the contract app and send them, please read this. I have also got the OTPs from the buyers and the sellers, and they're like, accept it. Because there's some glitch sometimes with DLD and you have a network error.
Or they read and they make assumptions about the contracts, almost like it's all going to be okay. So I actually assisted a broker a couple of weeks ago for his first purchase, and I said, let me go through the contract. And he's a broker, he's a very senior broker, he knows the contract well. And we were looking at the valuation clause. You see a lot of time with mortgage buyers, he had like a 10% valuation clause in there. But I said, do you understand what that means monetarily? Like how much extra? It was like, no, 10% sounds fine. 10% doesn't sound that big. But when I actually broke down the amount, I was like, do you have this extra amount just in case? And he was like, no. And I was like, then you really need to renegotiate the percentage. So there's a lot of assumptions that go in that we can help clarify. This is what it means if this clause comes into effect. This is what it means to you personally. It might cost you more. You need to just check everything. And we're quite happy to help people with that.
So as we are talking about that, we will come back to the whole process of signing a deal and then, but yeah, but what we can do is we can address these clauses before, like one of the clause, as you said, most of the agents and brokers put up 10% just to be safe because they don't want to lose on their commissions. But
If the buyer doesn't have the money, then the
buyer
contract
ha-
doesn't go
But
forward.
the buyer is not reading, because what the buyer reads
exactly.
is when they go in the contract, they see the first 2 pages, which are DLD pages. Yeah, the main, and they're like, okay, it's fine. Maybe they don't have that time to read the whole contract, especially the last part where we have added some clause about the 10%. If the mortgage valuation is low or more than 10%, they cannot back off a deal. So I want to discuss more about this. What are the important clauses that buyers have to look out for? one of this is that 10%.
Yeah, I was going to say any mortgage buyers, yeah, your valuation clause and also subject to final offer letter. It's very, very rare and unlikely that the bank would retract it after you've got your pre-approval. But if something happened and the bank forward it back, you don't want to be stuck in a contract that you can't move forward on. To that, especially.
NOCs, fully authorised for any modifications to the property.
Yeah. For me, tenancy contracts are a big one. It's a really, really big area of problems that always comes up. Often sellers may say that, so, yeah, I've had a discussion with the tenant, they're going to leave next week or they're going to leave in a month, that's fine. But actually, no, they need 12 months notice, or the tenant hadn't had that conversation, or, there's different sort of caveats to that. I think it's important the buyer has a clause in their understanding they're taking over that tenancy. They understand the laws of having a tenant in Dubai and know they're going to have to follow that correctly for the duration. So that's a big one for
With the
me.
tenancy, usually it is doing the calculations, pro rata calculations, transferring the rent, the security deposit,
Yeah, make sure the
making a
seller has
new
that
tenancy.
money
Yeah,
ready to use. If they've cashed the check for a whole year in advance, have they still got that cash ready to?
I have had an experience where I had to collect a post-dated check, ask the buyer if he's okay with it, collect a post-dated check of around 1 week later, and then give it to the new buyer, and the property is still rented. So I agree to that point. But yeah, so valuation, tenancy, NOCs for any extensions, modifications, or any such. Is there a way, like usually people don't know the consequences of, not honoring the contract?
In terms of the security deposit, you mean? Is that? Yeah, 100%. I think people skim over it and you don't realise that normally you have to pay the agency fee still, or pay a 10% penalty and all of those details. They need to go into it and read it through with a fine-tuned code.
People actually don't know what will be the consequences. They will be like,
I would say the majority people don't read their contracts. They either trust the agent or they've done it when they just signed and that's it. And then later on, again, even coming back to the sales progression fee or the conveyancing fee, sometimes it's handed over to us. We've done everything. Then I say, well, what's that fee for? We didn't agree to that. It's like you did it. It's in the contracts that they've not read and they've not seen it, and it's all the fine print, the terms and conditions. So that
I had that experience. So there's a property, 3 owners. I am talking to this one owner. Like, I came in contact, somebody gave him my number, I'm in contact with him, and I did convince him, and he's okay to pay the conveyancing fees. He accepted that. The contract is accepted, everything is done. On the transfer day, it's like, this was not known to the other 2 sellers. It's like, but I spoke to Mr. XYZ and I told him that there is a fee that my company charges, and this is just to make your process easy. And we had an argument, and then I was like, see, I cannot help it. It's in the contract. But then I had to have an exception, and I was like, it's okay. They're like, no, the market price has increased. So that's another problem usually people face, that if I am a seller, I am selling my property, I've signed a contract. Now, the contract has a timeline of 2 months and 30 days extension, right? Okay. So 2 months are almost over. I have requested for a renewal of 30 days extension. The seller is not ready to extend. He's like, no, we either transfer it in this time period or we don't do it.
yeah.
So is the seller, I convinced him to extend it for 15 days more, but is the seller like he has no other choice? Is there a mandatory law by DLD or RERA where it automatically extends for 30 days, like, or is there a way out? Is there a loophole?
Depends on the contract. If you've signed a contract with those terms in, then you're legally bound to that contract. If the contract says that after 2 months, if there was a delay from the third party, you are contractually obliged to extend for 30 days, then yes, you've signed and agreed to that. Obviously, with the system, we have to do it electronically. So yeah, if it's not in the contract and it says no, if it's not transferred after this date for no reason, then it's a different conversation, because it all depends on what's signed in there. But anything that ends up going to court, they are going to follow what's in writing. They're not going to follow the conversation you had over coffee. They're not going to follow the quick conversation you had on the phone. They're going to follow what's in writing. So anything you've agreed to has to be there.
Has to be in writing. But in case I have not put in the 30 days extension clause in there.
No extension.
No extension
Then no.
clause, but there's no clause which states that the transfer has to be made in this time period. So either of clause is not there. Then what happens?
You'll still have the MOU date on
Yeah.
the contract though.
So the electronic Form F has an end date. So if it's not done by that end date and there's no other extension clauses in there, then the seller does have his right, or buyer, whoever, to pull out of that break.
What happens? What happens if somebody has not honored, or what? Have you had any such experiences or any such cases?
It's the most common one, actually. It's always about money. At the
It's
end
always
of the
about
day.
money.
It's always about money. Like, let's say it's a cash buyer. He may have assumed, like,
Because I agree, after maybe 2 months, the market price of that property must have gone by 3-4% up, 2% up. You never know. The seller might be getting a extra 100,000.
he'll definitely be getting offers. They always do, right?
There are other brokers and they're like, get off that deal.
always someone in
I'll
his
get you
ear, yeah.
3% more.
Yeah.
Yeah, exactly. So it is always about the money. If it's a cash buy, it might just be him bringing funds into the country. Might be taking him longer than he thought. May have assumed it had been very easy. Like, I've had situations where it's the sending bank in their home country that they're having issues sending the money. They might not be able to send it all at once. They might want to send it in tiny little bits, like every week or every month. And the buyer had no idea that was going to be the case. But the most common one we face is with banks. Obviously, when you brokers put a deal together, they're making assumptions on the speed that the bank can go at, because no one in the deal actually works directly for the bank. So that's why we have the extension clause to say this is how fast we think the bank's going to be, but we can't take for granted the fact that we're not intimate with like what's going on with them. Are they overworked? Are they understaffed? Maybe they just have like kind of long procedures to complete their final offer letter. When it comes to the end of a contract and there's no extension clause, ultimately the seller can walk away if they choose to, if you go past the date, because there'll be nothing in there to legally keep them in there. You'd probably have to go into some kind of conversation with him. I mean, what we normally find, as long as we've been open and transparent with them throughout the process, and as long as it's not going to go a ridiculous amount of time over the process, they're usually happy to continue because the money's almost there. And as opposed to starting the process again, waiting months, even if it's an extra 2% or 3%, it's still months away, and they could be in the same predicament, whereas the money's right around the corner. If you do have the extension clause, then yeah, they're legally bound to honour it. RERA and the DoD won't automatically extend it for you. They still have to agree to the extension, but they're legally bound to, otherwise they could be at default.
If there's no extension clause,
If there's no
and
extension clause and you go past.
Yeah, and it got passed, is the buyer penalized for not doing in that timeline?
There's so many
I know the
answers
seller,
to that question.
the seller is in the power. He's like, my documents are ready. You are not ready. You pay me 10%. We have it in contract.
I think, yeah, that there's as clear cut as that. Yes, probably, but no case is as clear cut as that. There's always, something that's happened before. Maybe that they couldn't get in for the valuation because the tenant was difficult, for example, or maybe there was a document they were waiting on the seller's side that delayed something on the bank. But there's so many grey areas, as we call them, so many questionable parts that we couldn't possibly say, yeah, that is clear cut and that will go. My advice to any clients and agents is always just to avoid any situation going through the legal system, because as soon as it does, if you get to that dispute area, everyone's going to pay fees. The seller's going to pay fees. The buyer's going to pay fees. No matter who wins, everyone's lost time, stress, money, and it's not the best scenario for anyone ultimately. So, yeah, if it's that clear cut, seller could potentially go to the courts and say, yeah, he didn't complete on time, I want my 10%. Yes, that can happen. But there is, like I say, so many caveats that it's impossible to say that will always happen.
If I want to know more about it, because as a broker, I think most of the brokers have never experienced any dispute. Very rarely, maybe 2 or 3% people must have experienced some kind of disputes. But how does it, have you experienced any?
Yes, yeah, I've experienced a couple. Like I said, I've been doing it a long time, so definitely, I'd say it's a small percentage though, which is good. I think most cases can be saved, and most have a solution one way or the other. But it would go through various stages in the court. You have to hire a property lawyer to represent your side. They put various documents with the courts. They provide evidence. The opposing side get a chance to argue that. There's waiting periods. I would say you're looking at a minimum 6 to 9 months for anything like that to go through. And like I say, it depends on who's arguing what and how complex the deal is as to what happens. But like I say, both people will have to pay their fine. It's not a case of no win, no fee. You pay your lawyers up front. And there's a lot of time and stress involved in it. So if you can avoid it, don't. Ultimately.
No, but sometimes the sellers, because they are in the power, because the time has left from the buyer's side, they want to have this 10%, and I can say they be like, "Read, no, I'm going to give you a notice. I need this 10%." But just for knowledge, both have to go to court, both have to hire a legal firm from the seller, from the buyer, and then the court decides whether the buyer pays or no.
Normally, before that process, you would raise a dispute with RERA and give RERA an opportunity to mediate. So it would be like the broker would be there, I would go if I was involved, buyer and the seller. And you sit with a member of RERA, the DOD and DERA, and they will try and mediate between the buyer and seller. Generally, RERA will always favour completing the deal. They'll say, look, where are you up to? Like, he only needs a little bit more time, or she only needs a little bit more time, blah, blah. And they'll always try and complete the deal. If they can't resolve the dispute, then RERA will advise to go to the courts to be able to follow the legal route. And then, like Lauren said, they would have to kind of get legal representation, find lawyers, start bearing the costs involved. The seller can't just say, in your example, I've got the check, give me the check. Broker doesn't have the right to give that check to anybody. It's not the broker's property, it's the buyer's property. So if the buyer doesn't agree to give the check, only the courts can come in and order the check to be given. So even if the seller thinks they're entitled to it, the brokers, anyone involved, we're not adjudicators. We don't have the rights to give it. Only the courts do. So that's why we need to hold it legally.
So as a broker, and as I am the broker from an agency, my agency holds the check, and we do mention that on the contract F.
Yeah.
Okay, so I am holding the check, and if there is any dispute, I am not supposed to hand this check to the seller or deposit this check. I
Not
don't have
until
that
you've
right.
got the court order.
Even if you personally agree with the seller that the buyer is in default, you just don't have the right to do so. If you were to give that check to the seller and then the buyer took it to court and the court sided with the buyer and said, actually, you were in the right, that I think the seller should have that check, then the broker would also be liable because they're giving the check away. So they just have to hold it and then follow the instructions of the court when the court instructions arrive.
So this is a very good piece of advice for the brokers out there, for the agencies out there. Do not give the check to your sellers if they have not honored the contract F. You have to have it with you guys.
100%.
So
Yeah, just have to hold it until the courts intervene. Yeah, hold it in a safe and then just do what the court tells you to do when they tell you to do it.
coming from that, as a broker, I have the buyer's check. Sellers usually don't give the check. How do we hold sellers accountable? I know that their property is with RERA, we can block it. But just for buyers and sellers to understand, because usually sellers feel that it's easy way out for them.
So just because they haven't physically given a check, they're still liable to that. And that, like we just mentioned, that whole process, if that goes through, they will still be liable to pay that regardless of whether there's a check or not that they have to do. So again, the court systems work in such a way that if there's a check there, yeah, great, that would be cash. But say if that check bounces, say if there isn't a check, then they would start taking that from other assets or put travel ban, etc. All the different procedures the court.
They can, if I raise a dispute on the seller, like I have my funds ready, the seller is backing out. So either the seller pays me 10% for what we have agreed, or as a buyer's broker or as an agency, broker who is, brokering a deal, I can put a hold on that property with the title deed in the RERA by creating a dispute that they cannot rent or sell this property until this due has been.
I don't know the full details, being completely honest. I think, yes, eventually you can, but you have to go through and win that court case as a non-appealable, so you have chances to appeal your cases. And as I mentioned, that can take months. So by that time, he could have already said it. So it's not a clear cut, right, okay, we'll put a block on until it's resolved. It's you'd have to win the case first for them to then hold that asset accountable to pay the money back. So I could be wrong on that. Like I said, I'm not a lawyer and I don't have the exact details, but as far as I know, it's still a risky.
But there is a possibility to block the property.
Yes,
Is
but there is a possibility to block a property, but like Lauren said, it wouldn't be indefinite. I think they normally lock it down for a set period of time.
Will be after a dispute with RERA.
So
With the RERA,
RERA might lock it down for say a month, but like it won't be indefinitely. They can't just hold an asset. Court case can take years, potentially like 6 months, 1 year, 2 years. And the result of the court case is just to say, okay, now they owe you 10%, not that they owe you to have to sell you the property. That's, you know what I mean? So it's more about the money than the actual asset itself. I had a case in the past where the seller backed out because he was offered more money, but the increase also covered the 10% he would have to pay to the buyer. So he took the hit, but still went through the court process just in case he won and lost, and then the court ordered him to sell the property. He'd already sold it during the court process, but he paid the buyer in the end. But
Yeah.
he paid them 10%.
yeah, because I had one of those. I had a client who had a commercial property and who was like, Mansoor, I signed an MOU at this price. Now, because I know you, I want an advice from you that I have an offer which covers this 10% and I still save more 10%. So the hike is of 20%. So you think I should take the hit and go for it? I said, see, it's not about the 10%. It's morally not ethical to do this to your current buyer, point one. Point two, it's not that easy that you dishonor a contract and go to DLD. The time period is over. I don't want to sell my property. Take the 10% and you're walking out of it. There's a big process. You have to go.
I mean, if the seller pays the 10% straight away, if they say, yeah, here is 10%, I am defaulting, there's 10%, there is no court case to be had because they've paid the penalty to come out of that contract. So in theory, yes, he could do that, but like you said, it's not ethical. It's not really the right way of doing things. But in terms of legality, if he's paid his 10% deposit, there's no benefit for the buyer to then take it to court.
But I think then the buyer can say that the property has appreciated. You're just giving me 10% and brushing me off. I don't want this 10%. I want to buy the property. I have the money. Let's go to the court. And the court will rule in the buyer's favor. I know that.
But they will in the buyer's favor, but they won't
get the property.
Won't force him to sell the property to him. They'll say, yeah, he's defaulted on the contract. The penalty is to pay 10%. They won't say he has to sell it to you.
Oh.
That's the difference. So that's what I'm saying. So the seller pays it up front, pays that 10%.
And he's like, it's done, and that says, okay, I take that higher off.
By mutual agreement, we call it. So we'd probably have documentation created, and like this is the other way you could release a check if you have the permission of the check over. And the seller can say, I will pay you 10% to leave this contract early. I will honour the default clause of this contract, and I'm prepared to give you the 10%. Usually that's the best solution, to be honest. It means you don't have to go to the courts, pay all the fees, get everything signed, get everything witnessed. Money changes hands.
Okay, if the buyer and the seller mutually decide that we want to get off this deal, nor I pay you 10%, you don't pay me 10%. Let's just get off this deal. Let's get off this contract. Who pays the broker? Or because I have recently, like last week, I've had this experience.
Mutual cancellation.
Mutual cancellation.
Yeah.
Are they obliged to pay like 50-50 to the broker because broker has given his time?
I've seen it more frequently coming up, and maybe that's advice to brokers really, is to put a clause with special conditions to cover exactly that. If buyer and seller agree to disband this contract, there is still X amount owed to the broker to be paid by whoever, and specify it in there, because there is no set sort of standard on that. Really, if the contract doesn't go through, it all becomes null and void, and therefore the commissions aren't due. However, if it's mentioned in there, then you can protect yourselves in that way. but it's yeah, unpopular opinion if you like. It's not once that we well, the agent and ourselves are a witness to that contract. We're not parts. If the two parties decide to disband that contract, the terms are null and void. So you need to put something in there specifically.
So I had an argument, it's very fresh last week, with I was brokering a deal in an A to A. So the other agent, what the buyer's agent and the seller's agent, and I put up this clause: if they mutually decide to come off this deal, they still pay 50-50 to the broker agency fee. So the other broker, the buyer, addressed the clause that this is something that I don't want. If you're mutually understanding, why do we pay broker? I said, exactly. Why do you pay the broker? I found you the property. I negotiated for you. I've made the contract for you. I've brokered the deal. I've done my work. Now, if you decide not to buy, he decides not to sell, what's my fault? I've done my part of job. I'm supposed to pay for it. I'm supposed to get paid for it. If you decide mutually, you still owe me money. But then the buyer was like, no, I'm not going to sign on this. And the buyer's agent was like, yeah, he's fair. I was like, how? In which way do you hear that? And that makes sense to you, because I'm not the one who's getting paid. You are going to be paid as well. So you have done your job. They decide not to honor the contract, and we don't get paid. So unfair.
Yeah, that is unfair. That is, and like so, yeah, if you can put a clause in there and they agree to it, great. But
Is it? But sometimes they do address it. Few people read the contract as well, Andy.
But even in the default where buyer or seller pursue each other for the 10%, we always see or have the clauses in there that says out of that 10%, 8% goes to the client, 2% still goes to the broker.
20% goes to the broker.
Yeah. So
Yeah.
sorry, yeah, 10%, up to 10%. But yeah, the broker should still always get paid. That's how we feel about it.
yeah,
Need to secure their commission.
Moving forward, coming to the whole procedure. So after signing the contract A, contract B, contract A and contract B are basic contracts. In contract A, the seller gives you as the broker the permission to market the property and to sell the property. In contract B, the buyer gives you the permission and gives you the authority to be his broker and find your property. These are the contract A and B terms, guys. So coming from that, contract A, B, A done, contract B done. MOU, we take your advice, put in the clause, you read the contract, we approve it. After that,
depends on what type of deal it is. There's various different answers. So the differences could be if the seller has a mortgage, if the buyer has a mortgage, if it's a primary resale, like you mentioned with a payment plan, if it's just cash to cash, if it's mortgage on both sides, or if it's a cash buyer and a mortgage seller. Do the bank need to block the property before we clear the settlement, clear the liability? There's different caveats. Do you want us to go into full detail on each case and
no,
what's
just
a little overview on
brief, yeah.
to cash
What
to cash
happens?
is the easiest. You get an NOC. You make sure the buyer's funds are in. First you get an NOC and then you go to transfer. At transfer you turn up with manager's checks. Either the buyer or seller need to be there or represented by a parent.
To make it easy, after the MOU, if there's a bank involved, we ask for a valuation.
Pre-approval first. If your buyer's not, normally you should get pre-approval before they've signed the Form F, but if not, they need to finish that process. Do an independent valuation on the property.
Value sheet pass.
Then final offer letter, which is the letter that confirms all the terms of the mortgage. If there's then a mortgage on the seller's side, we would get a liability letter from the sellers, which tells us exactly how much is outstanding. Then an NOC from the developer. And then we go to the land department to do what's called a block on the property first. So because there is money being paid on the seller's side.
I think this is in mortgage to mortgage.
A mortgage or a mortgage seller cash buyer. You only want a mortgage buyer. But yeah, so there's so many different sort of.
Yeah, we will be coming to that.
Yeah.
So, okay, we can also do this.
Yeah. Just a mortgage buyer first, cash seller. Yeah?
Yeah, mortgage buyer, cash seller, make it
pre-approval,
simple.
valuation, final offer letter. Then we get an NOC from the developer, and then we go to transfer. We get managers check prepared and make sure the funds are bought, and it's goes to transfer.
Which is the most complicated process in this, part in this whole process? Complicated or difficult
For that
part?
type of deal,
NOC?
Depends. Yeah, it depends on the developer or the bank involved. I say.
I think I see conveyancers if I am doing a deal in an A to A, like agent to agent. I see conveyancers as getting two agents and one mortgage broker and buyer and seller, all these 5 to 6 people on the same page.
Yeah. You're the glue. You bring
It's
everyone
like a
together.
little
Yeah.
connector connecting all the 5 dots and then going to the trustee office, because that's the most. Am I right? Correct me if I'm wrong.
Yeah. 100%. Yeah.
Correct, yeah.
That's what I feel the conveyancers do, and which makes it easy, because sometimes it's the buyer's agency, the buyer's broker's agency, sometimes it's the seller's broker's agency having some issues, sometimes buyers having issues,
Yeah. You
and they
become that
address it.
central point. Yeah.
Central point.
Exactly. Yeah.
Central point. Okay,
Like
anything the buyer has, the conveyancer can answer.
Yeah,
Can answer.
exactly. And same, we can chase the banks. We can put pressure on them. We can do all the follow-ups and yeah, get everyone working in sync as well. If we know what's going on with the seller's timeline, we know that information to then coordinate with the banks and with the buyer and get that final chance to booked in.
Okay. Just coming from that, now we go to types of deals. We have
So, sorry.
types of deals.
Okay.
Cash to cash.
Cash, cash seller, mortgage buyer, mortgage seller, cash buyer, mortgage to mortgage, and then all of those four with a resale, they're slightly different. A primary resale, if there's a payment plan involved, it tweaks the process along.
Which is the most complicated deal?
I would say mortgage
It's a payment plan?
payment plan. Yeah, that would be my
The payment plan is more complicated?
with a mortgage buyer. Yeah.
With a mortgage buyer.
Yeah.
Okay. I think mortgage to mortgage is also super complicated.
Again, depends on the banks. It's there's different.
Because different banks have different
processes,
timelines.
But yeah, different timelines. Different procedures or compliance checks they have to follow can impact the rest of the process as well. So it depends.
Well, I have had a difficult time with mortgage to mortgage.
Yeah. It's the time that it takes with those. There's more documents involved, so therefore there's more delays and then more problems that come from that.
I was lucky. I had the both buyer and the seller, and both trusted me, and both were like, Mansoor, okay. I extended the contract twice just because it took that much time. And this was a time period of vacation. So the banks were on leave. So it was a nightmare. I had to convince the bank. I had to request the bank. Oh my God. It was, I felt like, what's happening? Mortgage to mortgage is so difficult. And I literally thanked the conveyancer, because the conveyancer was like a lifesaver for me in that day. Managing the buyer for me, managing the seller for me. And I was also there handling it, but she was the one who helped me throughout the process.
It's also about managing the banks, making sure people have done their job. Like everyone involved. Like sometimes you have to go and follow up and say, have you actually contacted the person you said you were going to contact? Has that email been sent? What's slowing it down? Where's the block in the process? Let's find it and fix it. So it's like over communication just to make sure everyone's on the same page. Even though Dubai is very streamlined and modernized, there's still lots and lots of people involved. More people involved, the longer the chain of communication, the more likely you could get a break in that chain of communication, especially with like really large institutions.
Coming from that, sometimes I've had conversation with mortgage brokers. Mortgage brokers are like, in a mortgage deal, they feel they're doing most of it. The bank will ask for the documents, the bank will set a date with the trustee, the bank will do everything, the bank will send the documents to the trustee office, they will book an appointment with the trustee. And it's like, why is the conveyancer required?
But they only send their documents to the trustee. So when you say the bank send it all, they send their bank documents and the buyer's documents. So who's sent the seller's documents? Who's checked the NOC? Who's I don't know if there's other caveats. Who's checked the NOCs for modifications? Where are those bits? They do a lot for the bank. Obviously, they for the buyer. Sorry, they're obviously obliged to do that. But who's communicated that with seller? Like you say, who's become that central point? Who's flowing it through to all parties to make sure everybody's there? Have the bank sorted out the rental refund? Have the bank sorted out that the seller's moved out on time? There's all the other.
Talking to you guys, and after my experience in Dubai real estate, I think you guys are the unseen heroes. saving a deal day by day.
Yeah. Well, look, like we said at the beginning, you don't want to have someone to deal with all this. You want it to go smooth and be an easy process, but it's just not. And it's nicer to have someone there holding your hand, if you like, throughout.
I need an honest answer. Do we need a conveyancer in a cash-to-cash deal?
Sometimes, yeah, I was going to be my answer. Yeah. It really depends. For example, I'll use EMAR as a developer as an example. Fantastic process. You do an NOC online. It comes within a day. You go to transfer. If your buyer's money's here, the seller knows how to use the app. No, you don't, because it's very basic and they can get it through. However, if you're using a different developer, if the buyer's funds are overseas, if one of the parties is overseas, or there's more complication to the deal, then I would say yes, because you're bringing other checks.
Like in the Palm, in the Marina, in JLT, there's lots of like kind of developers that you might not be as familiar with. Do also have utilities providers who might also have utility providers. So
you might need 2 or 3 NOCs to get to TAF.
4 once. Yeah. One from the chiller company, one from the
Building management, facility management.
Exactly. And then you have to get one to get the other one to get the other one to get the final one that you need.
Before that first one expires. And
Yeah. So see, when we are talking about a deal size of 50 million, 20 million, anything about 10 million, I think the convincing fees is not a point of concern for those kind of buyers and those kind of sellers. They're like, okay, it makes the job easy. But when we talk about ticket size of 2 million, 3 million, because these are the masses.
Yeah.
These are the masses, like these are the most frequent buyers. I have a client who has property worth 15 million, but he has bought like multiple properties. So for them, a fees of 8,400, correct me if I'm wrong, is they feel too much. Or even if we split it, 4,200, 4,000. So for a cash-to-cash deal, do you think this kind of fee structure is?
I think at that point it's more about security. Like ultimately, yeah, you can probably figure it out on your own. If you just want that security and confidence to say, we know this is perfect, we can go now to the DLD trustee and do it, just follow our instructions, then that's where it comes from. But it is a confidence thing. They may have done loads of transfers in Dubai and they know what they're doing. I would probably suggest if it's your first time buying, it'd be better to have someone like us to support you. We do a lot of following up with the trustee directly during the process as well. Try and make sure everything's good to go. We don't want any problems at the transfer appointments.
Sometimes I feel the brokers just do the finding a property, getting an offer, negotiating, and then the job is over. And because I've had conveyancer friends, I have one friend, I talked to her, she's done a lot of conveyancing for me. And she's like, Mansoor, it's been days, I've given quality time to my son. Given at night, 10, 11, 12, I'm on my phone, I'm glued to my phone. So,
it can be a stressful job.
It's a stressful job. I think so. What do you think?
I think real estate in Dubai in general, agents as well, it is a stressful industry. The highs are the highs, and it's great when everyone's earning money doing it. But the reality is that people are working long hours. People are on call at the weekends, on call in the evening. That's not different for us. Yes, there's a certain limitation in the sense that offices shut at 6 o'clock, so we can't chase up some people. We can't do a transfer at 9 o'clock at night. But if a transfer's happening the next morning, we're going to have to be on the phone there. So yeah, it can be stressful. You're also taking on, going back to that mention of us being the central point, we are the central point for people's emotions. And some of the hardest cases I've had have been divorce cases, for example. They're selling because they've chosen to separate, and there's a lot of stress and an emotion involved with that, and it gets put on you because you have a conversation with the husband, for example, who you've then got to relate it to the wife, and then something goes wrong. It's a turmoil, like it can be sort of a roller coaster, shall we say. You can go up and down with these emotions. So taking that on for 20 deals at a time, however many you've got, it can be stressful. But yeah, that's obviously with any job, you have to put your own boundaries in place. But
I've seen conveyancers become more close to my buyers and sellers than I am.
It just tends to finish that way, yeah.
I went soon.
Maybe next time my buyer wants to buy a property and he's not calling me and he's calling like, hey, Lauren,
Yeah, 100%. So that's
Who is the best agent? Do you think I should still continue with Mansoor or should I go to someone?
I saw an old client who was my client from 12 years ago, I think it was. He's moved to New York. I saw him when I went. I was on holiday. He's like, yeah, come over, come see the family, everything. You become integrated in people's lives. That's the nice part of it. And that's, you get to know people. And yeah, I like that bit. But
That's amazing. That's amazing. So, if I want to ask one of your worst experiences and best experiences being in this field,
I would give a more general answer. I think I mentioned previously, divorce cases are my worst. They're always so complicated with the emotions that are involved. Whereas the best experience to me are people who are buying their first home to live in and they're really excited. You know, they've saved wages for the deposit. It's a big deal and it's a really exciting moment for them. That's my sort of favourite. You've had some really bad.
It's like mainly emotional things. You get like emotionally attached to the clients as things are proceeding. So like when it comes to best, like a new family, they want to move into a house and they want to move in by a specific time, but there's been delays for some reason. And trying to get them in there and they're like desperate to kind of move in, that can be quite tough.
by worst, I mean any of the cases you've handled and the deal has gone off, and either of the buyer and the seller has to pay 10%. Like it's gone worst and worst to ugly.
I can give one that it was a villa that sold. The buyer was bringing money over from I think South America and missed the first deadline. We agreed an extension, missed the second one. By the third time, they said if it is not completed, not bought over by that time, then they're gonna have to pay the 10% penalty. 10% penalty, sorry, which they did. Sorry, they missed the next timeline, so then they did pay the 10%. Then a few months later, they went to court and tried to claim that we shouldn't have taken that 10% and tried to claim it back again. So that was quite messy. They should have paid it. They'd signed an agreement. You know, all the documentation was there, and it was fine in the end. But it was quite
But
messy
did
and
they
quite
end
complicated.
up buying that property even after paying
No,
10%?
it got resold to another buyer. So they paid the 10% because they after the third extension, they knew they couldn't get any more time. But then after paying it, they tried to claim it back. So that was
Coming from that, if there's a property, such thing happens, is there a problem for seller or does he face any problem to sell this kind of a property? Like back home in India, if I compare, and anything such happens, there's a litigation. People go to court. There's a case that property cannot be sold or bought until the court has resolved that issue. So anything that kind of stuff happen here in Dubai? Like I've not had any experiences where the deal is going off.
It's slightly different. Like we mentioned before, if it's to do with the 10% or the deposit or penalty payment, whatever you'd like to call it, it doesn't affect them reselling the property. So on this example I just mentioned, that there was actually a whole signed agreement. We didn't go to court. It was initially there was a signed agreement from both parties saying that the seller understands, or everyone understands they're not extending. The seller wants to claim the 10%. The buyer agrees to pay the 10% and is handing over check detailed, and it was paid and that was signed. It was only after that they went to court to say, no, actually, we didn't want to pay that. We wanted back. So it was a bit more complicated. A court wouldn't, as we've mentioned before, the court wouldn't block the property straight away if you were trying to claim there was a default or dispute on the contract. But if you're found to be guilty later, if you owe that money and you haven't been able to pay it, the court can put blocks against properties as an asset so that when that property is resold, they know the money will be paid back. Does that make sense?
That does. That does. That's what I was looking for.
Yeah, but it's later down the line. So as we mentioned before, that timeline could be quite long. And if the seller has sold the property before that, then they can't attach it later on. It's already sold, it's gone. So they have to claim it from somewhere else.
So if we have a comparison, because I know you guys have been doing this in UK as well, right?
No, I didn't do it in the UK. I know I bought properties
you know the
myself,
process.
but I haven't actually practiced there.
But
My
if I,
family does it in the UK.
yeah, so I remember from that. So how different is the process from UK to Dubai? I can compare it to India. I know the process here is quite easy and I can say best. In India, it gets messy.
and it's even in the UK it takes longer. The main differences are that in the UK, even though the broker will find the property and find the buyer, they don't make the contract. The contract is made by the solicitors, so the buyer will have a solicitor and the seller will have a solicitor, and they will communicate with each other to make agreements on the contract while also vetting the other side's party. So the buyer's solicitor will be vetting the property, see how old it is. In the UK, there's lots of things. Is it on church land? Has there been coal mining in the last 200 years? They check lots and lots of things. And once they're happy that everything's fit for sale, that solicitor will want to continue. Seller solicitor will do the same for the buyer. And once they've agreed contract terms, the solicitor sends the contracts to each other, sign them and send them back, and then the contract's made. But usually in that process, any issues or problems that you'd find in the course of the sale will have been found pre-contract and either ironed out or agreed on how they're going to fix it during the contract. And then they proceed. Everyone's sort of fully aware of what's going on. In Dubai, brokers make the contracts. And they don't do the same level of vetting as a solicitor would. Like, it's more faith-based. Like, you take people on their word, really. And not to say that people might not be honouring their word, but they might not be fully aware of their entire situation when they agree to a contract. They might just think it's okay.
I think the reason brokers do the contract in Dubai is because the process is super easy.
It's a lot simpler. It's a lot more streamlined.
DLD, on that note, DLD has made the process, RERA has made the process so easy that I can log in through my broker card, create a contract A, contract B, contract F, put in the clause, and the process is so simple and easy that it's not required.
But also I think as well as a comparison, some of the things you mentioned there, some of the coal mining, Dubai or the UAE is such a newer country. We don't have that same history. We don't need to check for protected land. We don't need to check if there's badgers on the land, things like that before they build. There's so many quirks in UK property that, sorry.
No, can I just give an example of what I was saying about the vetting? Stuff they might not realise. You can put a contract together, but it's based on faith, but or it's based on people saying, yes, I agree to these terms. Like, the buyer's basically saying, yes, I have the money I want to purchase. And the seller will be saying, yes, I have the property I want to sell. But we had a case not even that long ago where a contract was put together and the seller did not have the property to sell. It had been reclaimed by the developer. But he didn't know that. Like a developer had gone bust and then it had been bought by another developer. He assumed he still had the ownership, but he didn't. It wasn't his fault. But at the time of making the contract, he bought it was his to sell.
I don't think how can a contract be made if the property is not registered in DLD? I think you need a OCUD or a title deed to make any kind of contract. And
which he had. It's quite complicated. So he had the document to make the contract. The property was sort of like in a limbo in the DLD waiting to transfer back to the developer. So he still had a document, we still had a Form F. We didn't discover it till it came time to get the NOC. And when we went to go get the NOC, the developer was like, it's not yours, it's ours. That was basically the end of the discussion. He was going to get his money back. It all comes down to something that happened.
So he was going to get his money back from the developer.
He was going to get his investment back, but because of the change, and it was all over a period of about 10 years. Like, I think it maybe changed to 2 different developers. And it was just the way the process handed out. When the new developer got it, they're like, we'll take over the completion of the project and then sell the units. All the previous investors from the first developer didn't know that their units were going to be taken back and they were going to just get their investment back from the DLD. But this is what I mean, about no one saw that coming. And then if there's any issues coming, you have to kind of discover it during the process, see if you can solve it.
I can say that every deal has unseen hurdles.
Yeah. Sometimes we'll come across deals where running the deal, the bank is in the process of taking back the property and they want to put it up to auction. The seller knows he's got too much liabilities, maybe not paid a mortgage repayment for a year. He's trying to sell it to save his investment, save the property, but the bank's already initiated the process. So you might have to go to the bank and negotiate for more time and prove to them that we've got the sale going on.
Or even something like a default on a personal loan, for example. Again, they might know, the seller might know they owe that money on the personal loan, but think I'll pay that. Once I sell my property, I'll pay that off. But actually the bank's put something against the property to make sure that the money, and again, it's unraveling those kind of problems.
And older mortgages where the name on the mortgage is not the same as the name on the title deed, that can create problems as well. So you have to get like more evidence to prove that the mortgage and the property are like the same people. It usually comes up when you're kind of requesting for liability letters. Turns out a son maybe bought property for his father, but the son put his name on the mortgage and put his father's name on the title deed. Something along these lines creates complications. We need to go and find a way to fix it. But just as examples of unforeseen things, and like the mortgagee in this case wouldn't have known, it would have created a problem. So that's
Always unforeseen, suppose.
always, yeah.
Yeah. So just looping it back. So in the UK, they go through all these problems first before you exchange contracts. So yeah, it can take much longer in the UK. And also there's much more risk of that deal falling through before you get to contract stage. Whereas here we sign the contract, everyone's locked in, and you find a way to make it work after.
But there's where you guys come in. Is there any,
and that's why you need us in the corner.
any issues you, especially the company I work for and the team I'm leading, I know I've got chartered conveyancing covering my back.
Good. That's good. Yeah, that's what we aim for.
So, coming from that, what are the services chartered conveyancing as a company offers other real estate agencies, other real estate companies? And also, I have seen you guys having some exclusive clients, and they say that we have our own conveyancing team, and that's chartered conveyancing.
Yeah, I think to touch on that, as you spoke about before as well, we do create amazing relationships with clients. Sometimes they become a really good friend, and we hold that. So yeah, they do want to come back and use us. So any client is allowed to use us independently with any brokerages. There's no, even if a broker says they have in-house, and they may have the best in-house team, there's some amazing guys out there, but the client still has overall say on who they want to use, who they want to give power of attorney to, etc. So they can use us. But yeah, we do power of attorneys, golden visas. We can assist with property visas, gifting properties, eviction notices, anything really that is tied to the property, except we don't sell or buy the properties, but anything else we can usually cover. Have I missed any?
We represent to buy and sell the property.
Yeah, represent, sorry, but yeah.
So it's like professional representation. Golden visas become like a important thing for a lot of investors in Dubai. They want to buy to get the visa. We have both regular golden visa like process, but we also have an express service if people, because during the process they need to be in the country. Depending on how long they can be here, we can kind of shorten down the 2 to 3 week process to maybe like 3 or 4 days, and then people can get the golden visa on the investment and they can leave. We're pretty much happy to professionally represent in any capacity, buyers, sellers, whatever the next.
With the golden visa thing, I have a question. If I have bought a property like 2 years ago, the value of the property is around 1.5 million. Now that value has appreciated over the past 2 years and gone up to 2.2 million. Am I eligible to have a golden visa?
Yeah, we might have to do a valuation on the property, like a private valuation, just to get the evidence of its value. Because the title deed's only going to have the initial purchase price, right? So if it says like 1.5, but you're sure it's 2.2, I still think we'd need to have an official document as proof for the Cube, which is Dubai's immigration kind of section, DLD's immigration section.
Okay, so, but we could create evaluations.
Okay, because a lot of buyers have this question, a lot of sellers have this question that I have a property, I bought it at this price, but the minimum investment amount to have a golden visa is 2 million. This will help a lot of people.
And also just to note as well, they can combine properties. So say if they have 2 1 million dirham properties, we can use both of those to obtain the golden visa as well.
Okay, so with that, if I have 2 properties and both are attached to my golden visa and I want to sell one of them, how does that work?
You would have to cancel your visa. Once it drops below the 2 million point, then you would have to cancel the visa before we can sell the property. If they have multiple properties and it's attached to 2 particular ones, we can move the visa across to another property. But if that total value drops below 2 million, then we have to cancel the visa before the transfer is completed.
We have to cancel, but if they reinvest, do they have a time period where they can reinvest and get the golden visa?
Yeah, it's going to say 30 days. Again, case by case, sometimes we can get slightly longer depending on circumstances, but 30 days is a stat.
Maybe I want to sell my property and I want to buy an off plan worth 2 million or above that. Is it possible that within that 30 days, so I choose a property, I sell mine, and I reinvest in an off plan where I pay 24% upfront or 30% upfront, and then that property can be attached to my golden visa?
Yeah, as long as the total purchase price of the property is over the 2 million and the construction has started on the property, then that's done.
This piece of information is going to help a lot of sellers who are like, I want to sell my property, but I cannot sell the property because that attached to my golden visa. Well, a lot of people don't know this. Yeah. And they usually ask the brokers, and the brokers are not aware of this. Like myself, I wasn't aware of this.
Yeah. So yeah, so it's good. Glad we can help.
And they only have to remove the visa right at the sale point. So like even if you're in a sale, you've got a mortgage buyer, you don't have to remove the visa right at the start.
Yeah,
Just-
we
just
can
for the transfer
maximise that
point.
time. Yeah.
And then let the whole process, get the NOC, get the transfer.
Do they have to pay like extra fees or extra money to obtain this? Like, or can they put it on hold, pay a security deposit, put the golden visa on hold, sell the property, buy another property and revoke it? Is that a possibility?
I've done it in the past, but we always have to be aware that the policy is always changing back and forth in Dubai. Like it's like we have to constantly check with the DLD, with Q, is the policy still in process? Is the policy still in process? Even with the land department and POAs recently, they made a decision about POAs and went back on that decision. So yeah, we've done it in the past. We've had that 30-day grace where a seller bought a new property and he moved his visa to that property. But it's always worth checking before committing, just in case.
In Dubai, what risks do people think don't apply to them, but actually do apply to them?
So for me, it's probably, they do know it applies to them, but maybe they don't take it seriously enough, is the actual default consequences in the contract and how easy it might be to become in default if you don't prepare your contract seriously enough. Maybe being a bit over optimistic with timeframes or being able to get money. But a common example we're seeing a lot more lately is when, let's say you've put a contract together and let's say it's a mortgage buyer and a cash seller, and the contract's totally not going to expect the buyer to complete his mortgage, get their down payment, and then complete the sale. But then during the course of the purchase, we find out that the buyer's actually having their own sale and they need to complete that sale in order to gain the funds to complete the purchase in our contract. And then if there's an issue with that sale, let's say their property undervalues past the clause in whatever that contract is, that sale collapses, makes our contract collapse along with it, like a domino effect. But because they didn't declare what was going on, where they were getting their funds, no one thought to put in our contract the clause that says this purchase is dependent on the buyers successfully completing their own sale. And now the buyers put themselves at default because now they say, oh, we haven't sold, we don't have the money. That's not the seller's problem. So it's about really being honest about what your circumstances are when you're engaging with the broker to prepare the contract. The more honest you are, the more protections you can put in and the more fair you can make it. Of that specific example, seller might say, it's not my problem that you don't have the money. If you enter a contract, you're basically committing to having the money. I'm going to pursue you for default. The seller might not want to. Seller might just be seller might be really empathetic and say, oh, that's a tough situation, I get it. But the buyers have put themselves at risk. And it's not.
In this kind of situations, who do you think is at fault when anything for that matter goes wrong? The broker, the buyer, or the conveyancer?
Near big buyer. Like either they didn't declare it, or if they did, then they.
I thought concerning is quite a broad question because you need to know the ins and outs. That if the buyer has declared it to the broker and they've said don't worry about it, don't put it in the contract, then there's fault there on the broker. If the buyer's not declared it, then it's their fault. Because if they should have been honest and upfront, it's not a clear-cut answer. It depends on the conversations that have been had prior to making the contract, in my opinion.
The problem are these chains these property chains, very similar to what goes on in the UK. They weren't that common in Dubai, like until like maybe the last year or so, they've become much more common. So the contracts aren't really built to kind of be there all the time, to have the clauses in there specifically to address the chain. And also it might be harder for the broker to sell to the seller if they know they might have a delay while the buyers can.
So are you saying that if the seller is aware of the situation and the seller knows that there might be a delay of 30 days or maybe 15 days, then it's okay? If the broker is transparent from day one.
I very much, and honesty is the best policy, gal. I think if you, like you mentioned, if you can be transparent and upfront about your situation with us, we can solve problems before they become a problem. You can you can know the boundaries of where the seller's at. Okay, 15 days today is fine, but after that, it's going to be a problem for me. Or you can have that conversation. But it is hard, isn't it? You know, when you're trying to close a deal, it's not always that easy.
Just on a lighter note, I have you heard that saying, always be honest to your doctor and to your advocate? I would say always be honest to your doctor, advocate, and conveyancer.
100%. We can only help if we know what the problem is fully.
Yeah.
Have you had any experience or any examples where the contract is on, it's a 2-month contract, 1 month is already over, and then you guys, because things have got complicated, and then the agency or the broker has contacted you guys to come and help, and then chartered conveyancing comes in and helps them, and have you guys sorted such cases where
Yeah, absolutely.
you have come in the end portion of the deal?
Yeah, so it's harder. It's harder to deal with a problem that's like we say, so far down with the time pressure of having 1 week or whatever it is left on it. But yes, yeah, we can help, and we always will help when we can. But we prefer to be in the beginning, like I
Earlier, in the
say,
beginning.
navigate those.
Know every bits
Yeah, exactly.
and everything
Exactly,
what's
and try and
happening.
stop the problems happening before they happen. Ultimately.
So like,
Amazing.
like sometimes it's just a case of, it's always towards the end of the contract, because that's when the broker realizes it's do or dare. Like it's like, right, if I'm going to fix this, I need to get someone in. So I will get a call saying, we need you to come in now. We've got we have your fees sorted. Can you just fix this, please? Can you just fix this now? It's like, okay, let me see what I can do. Sometimes we know what to do. Sometimes we just need to connect the person to the right person. A kind of an example that happened a while ago was a buyer failed his medical insurance. He really wanted the property, but he failed his medical insurance because of a previous medical issue. But it was like a long time ago, and he was fully fixed. Don't want to go too much into the bit of private information, but it was just literally a case of connecting him to a different bank who would kind of had less stringent policies about that. He'd be past the medical with them, but we explained to the seller we just need a bit more time for this reason. He was really sympathetic towards it, but we came in and just basically networked him to the people that could help him best. That was kind of the crux of the solution, and then just making everything else happen as fast as possible.
With that, this question comes to my mind, that if we are in a contract and there is a clause in the contract that if the final approval from the bank is not there, the buyer can get off the deal.
Yeah.
Okay. And if this buyer is in a situation where he can get a mortgage from a different bank, but he doesn't want to go to that bank. He's working with a specific bank, ABC Bank. He wants to get his mortgage done from this specific bank only. But this bank has a set of rules, and they are like, we cannot give you a mortgage. You have a pre-approval, but we cannot give you a mortgage because final offer letter has some different clause maybe. In this scenario, is the buyer at fault, or should he go to a different bank? Like, what happens in this case?
The way the clause is written is like, if they fail mortgage approval, then they can generally leave. So you will see like modifications to the clauses that says if they fail, they will have a second opportunity to work with
They're chosen a broker, or they choose a bank.
specific, let's say, partner mortgage team that we know or that you know, and give them an opportunity to gain another FOL. But if this second attempt doesn't work, then they can go. So you see differences in the clauses.
If I read out that clause exactly, it's like, at the end, they have to find a way through the agency brokering the deal to find them a mortgage partner. And sometimes the buyers don't accept to add that. They are like, no, we don't want. We have a mortgage partner, we have a mortgage broker. If we don't get it from this bank, maybe they are already in a contract, but they're like, no. So if they're not getting a mortgage, can they still, they have an option of going to a different bank.
If they've been upfront about that at the beginning and yeah, again specified, it has to be from this bank.
If they're not,
It's grey.
specific.
It's a very grey area. Again, it's a really hard question to answer, I think.
Yeah, the way that the standard clause is written, if they've had a rejection or a failure to receive their mortgage, then generally they can leave, unless it's got that second part that says to have like another attempt with like a preferred partner, maybe a partner you know more. Then I would assume that they would be able to leave. But
Yeah, so they've got something in writing from the banks, and
you can't prove, like, even if they fail with one bank, you can assume they might be successful with another, but there's no like concrete way to prove that, right? It's just about them trying and the effort they want to put in. Like in the case I just shared with you, he was like very eager to do it, and the seller was willing to give some more time. I think it would be rare unless there was something in their finances that we weren't aware of, I think it'd be rare for a buyer to not want to have another opportunity to get the property. Unless maybe something came up during credit checks, they realised they wouldn't be able to get around. It might be to do with their employment status, maybe their company is too new. Things of that nature, really.
Yeah.
So if you could give me a few points that buyers should look out before signing a MOU, few important points that might affect their purchase or they have to be careful before signing an MOU.
Specifically the buyers.
Yeah, for buyers and sellers as well.
It's the most important ones are just making sure there's clauses in there that indemnify you against things that aren't your fault. So this mortgage, like failure to get a mortgage, is not their fault. That's something to do with the bank. The valuation clause that matches their finances. Obviously, we see in contracts it ranges from 0% to 10% normally. The higher the percentage, the more the buyer will have to put in if it reaches that percentage. If it undervalues by 10%, the buyer is basically saying, that's okay. I have the liquidity to make up the difference. If it's closer to zero, the buyer is essentially saying, I need this mortgage to get this property, and without the mortgage at the exact value, I can't do it. So they just have to be honest with what their finances are, have that conversation with us or a mortgage broker just to see what extra money they might need to put in. Modification NOCs, very important. Sometimes people have modified their properties or extended their properties and not done the due procedures with the developer and with the municipality, and they could have potentially done a modification that falls outside of the community guidelines. So if a buyer ends up buying the property and then say they want to do further modifications and during an inspection, the previous modifications picked up, they might have to pay for it, more to knock it down, depending on what the modification is. So it's always worth having that protection, especially if you're a mortgage buyer. The valuation can pick up on any modifications. And then you have to say to the seller, you either need to provide these or you need to go and get them.
I'd say move-in dates as well are important. If the buyer has a set time they have to be in by, is that a realistic time frame? Are we going to be able to get everything done in the time on their MOU? Have they allowed for any unforeseen delays so that they've got that covered? Obviously, if we're doing a mortgage-to-mortgage deal and they need to move in 2 weeks, it's not going to be possible. So having a look to make sure they're covered on that. And the same with the sellers. Do they need extra time in the property to receive their funds before they buy their next one? Or do they need some sort of leeway to leave the country before it's an empty property, things like that as well.
Yeah, they might be living inside it themselves and
Yeah.
need a certain time frame to leave.
Yeah.
They might say, we're willing to sell the property now, but we need to stay in it as either tenants or not tenants, depending how it's agreed.
Basically, put out all the truths, all the facts in the contract. Rented, notices served, the sellers are staying, they need 2 months time, everything. And I think the mortgage thing that you said, like 10%, usually brokers put 10% because they know the property valuation won't vary more than 5%. And what they don't think is, as a buyer, if I am a buyer, I'm buying a property worth 2 million, the 10% of that is 200,000, where I have to put up a down payment of 400,000 plus 4% DLD and 2% agency fee and 1% conveyancing fee. To be specific, I have to put more 10%. That's 200,000 more. Maybe as a buyer, I don't have that much. Maybe I can extend up to 50,000. This is a piece of information which every buyer has to think, and they have to modify that from 0 to 2, 3 or 5%, whatever is feasible or fits their budget.
To not just think about it as a percentage, like go and work that percentage and see what the exact number is that you might have to additionally put in. 5%, oh, that doesn't sound that much. It still could be a lot of money. So break it down, see what would happen and how much extra you'd have to put in, and then make the decision based on that.
What do you recommend?
The most common one we see is 5%, but it's really hard to make a recommendation because it depends on everyone's personal finances. Some people might have really stretched themselves to the absolute maximum and they need 0%, otherwise they won't be able to continue. Some people, like I've even seen a buyer who said, I don't need a valuation course at all.
Yeah,
Or whatever comes in, like I don't mind. So that's just in.
What happens to this case? The buyer does not have to the bank discovering.
If he has no valuation clause? Oh, if he doesn't have the money.
If he doesn't have a money,
So there's too much of
he's into a contract, he's buying, the valuation is
10%.
not 10%, I let you 3% of let's say 5%. And the buyer is like, I am stretched out, mate, I don't have it. How do I get this 5%? I wasn't aware of this clause.
As in, he's already signed the contract and the clause is in there.
Yes.
He's put himself in a difficult spot. I've seen it. I've seen it where it's downvalued up to the, like, say he's 5%, it's downvalued to 5%. Buyer's still committed to that
Then
contract.
can he renegotiate in that case?
Not if it's
No
within that
chance.
percentage, no. It could try. I mean, of
He could
course,
try,
you can always have
because
a
he doesn't have-
conversation,
otherwise
but
can he get out of that contract if he doesn't have? Can he get out of that contract?
not without
If it's 5%, if it downvalued 6%, yes, he can. But if it's 0 to 5, he can't. He's stuck in now.
He's stuck.
This is why it's very important to make sure that's properly checked before you commit to anything. I spoke to a buyer. This was a 10% valuation clause, downvalued like 9%, I think. And he said, I don't have the money. And I said, well, why did you agree to the clause? He said, well, I didn't think it would downvalue. If you didn't think it would downvalue, why did you have the clause in? And so initially, this was when I was a more junior conveyancer, so I was working in a bigger company. And the answer was like, well, he still has to buy it, but he didn't have the money. So what happens? We ended up referring him to some different mortgage teams. I don't know what the outcome was in the end for him, but like if you don't have the money, you can't do the deal. You need the money. Seller's not going to say, oh, that devalued 5%. You don't need to bring me that extra bit of money.
Yeah.
You need the money. So you need to be honest about your finances at the start. What you're capable of.
That's
I'm rambling.
amazing. No, I think this should be the most viewed podcast, but there's a lot of information that first time buyers and sellers should be aware of, because a lot of brokers out there are not honest and are pressured from their agencies to achieve the targets, and
yeah, well, sure, when I get the
for the matter of fact, they don't get paid, and they are doing this for commissions. So they push it from 0 to 10%. And they know that property valuation will be somewhere around 10%.
yeah.
Yeah.
The problem has to be faced by the buyer, not the broker.
But a lot of buyers are new and they've been like attractive. Dubai's attractive. But everyone wants to get involved with Dubai, don't they? So you get new time buyers and they're in a rush. They're in a rush to come in and buy.
Yeah.
And yet they might be pressured into it, or they might be seduced into it.
Yeah, or they might not understand, again, like talking about the UK earlier, they might think it's the same as the UK and we're not locked in for months. No, actually, once you've signed that paper, you're in, and if they haven't realised that, it's a bit of a shock later on. So
Also, the brokers create a kind of urgency that there's another offer from another broker, the deal might just go to them, so we better accept the contract. But if you're buying a property in Dubai, you should look at these specific clause where you don't get stuck.
And if you don't understand it as well, speak to someone like us or another broker or someone you trust to get that second opinion.
Exactly. You can always connect with Chartered Conveyancing, Lauren, Andy. I'm going to leave their contact details in the description and we'll be flashing as well, guys. How is it better to come to Chartered Conveyancing than having in-house conveyancing? What is the difference?
Neutrality.
Yeah, exactly. We're completely independent. I mean, there are some fantastic in-house conveyancers. Some of my favorite people work for brokers. So you can get amazing service. But obviously they're bigger, I would say bigger entities. You're going to have a lot of new starters as well. It's just about doing your research in terms of, as you mentioned, clients will ask to use us specifically because they've used us for years. They know us, they trust us. Do that same research with in-house. If you've got someone who's been there for years and it's fantastic, the job 100% use them and it's fine, but you will still miss that element of the independence or neutrality. Like you say, we work for ourselves. We don't have any preference to any broker. Of course, we want the deal to go through for them and we will always help and protect the fees, etc. But we are looking after the client. At the end of the day, the buyer and seller or whoever has instructed us, that's our main client. And we will make sure that the terms of the contract are adhered to it for their protection. So it gives the client that peace of mind that we're looking after them rather than just worrying about getting the broker's commission through. There's an element of getting the broker's commission through, but it's alongside making sure they're protected, if that makes sense.
We both started out in-house, so we both have experience working for these large companies before we made like an independent company. Probably we offer more flexibility and less pressure that it's just about getting the money to the brokerage. It's about treating everyone the same, treating everyone fairly. We want to protect everyone's interests, make sure everyone leaves happy, everyone, broker, buyer, seller, ourselves. So I'd say that's the difference. I mean, obviously the companies were very professional, took a lot from there, but we just added our own little...
I've seen that. I've gone through a few reviews and you guys have like amazing reviews on Google as well. Around
Thank
8
you.
reviews and
But,
all positive.
we do
Rated
care.
5
So we
star
want to
on
make
Google.
we want to genuinely want to make sure people have a good experience. It's never going to be perfect and there's always going to be hiccups, but we do care and we want to make sure it goes through.
Ultimately, we're professional real estate crops. So despite everything we've talked about, it's not the complete rep for what we do. If any broker, buyer, seller has a problem that they're struggling to deal with, come to us and we'll find a way to solve it. Close to the time cap. Can't promise that it's 100% successful, but we'll always, bare minimum, investigate it, see how to get around there. Maybe we can solve it, but people together to fix it. End question. Why is it there's no stupid questions? Not for us, it. So you have to bring it to us. We like challenge.
That's amazing. That's amazing. So finally, I think we have had enough information, a lot of information useful, which our buyers and sellers can look out for in the contracts and come to Chartered Conveyancing for all the help they need, for all the answers and all the solutions they need. And I think a lot of people can make use of it. Be careful before signing any contracts. And I think thanks a lot to Andy and Lauren for being there. It was amazing having you.
Great, thank you.